So let's start with the company law. We are doing from CA अतुल अग्रवाल सर्च IBS लॉ इंडेक्स लॉ बुक। तो फटाफट सिर्फ अपन को तो गो थ्रू ही करना। तो क्या है, तो पहले अपॉइंटमेंट एंड क्वालिफिकेशन ऑफ डायरेक्टर्स वाला चैप्टर है। तो पहला तो है बोर्ड ऑफ डायरेक्टर्स सेक्शन 149। तो क्या है, कंस्टिट्यूशन ऑफ बोर्ड ऑफ डायरेक्टर्स। एवरी कंपनी शैल हैव अ बोर्ड ऑफ डायरेक्टर्स कंसिस्टिंग ओनली इंडिविजुअल्स एज डायरेक्टर। मिनिमम नंबर ऑफ डायरेक्टर्स क्या है, पब्लिक कंपनी में 3 डायरेक्टर, प्राइवेट में 2, 1 पर्सन कंपनी में 1 डायरेक्टर। मैक्सिमम नंबर ऑफ डायरेक्टर्स क्या है, 15 डायरेक्टर्स कैन बी इंक्रीज बाय पासिंग स्पेशल resolution. Now, note, following companies are exempted from restriction to maximum 15 directors if has not committed any default in filing FS under section 137 and annual return under section 92। तो गवर्नमेंट कंपनी और सेक्शन 8 कंपनी को जरूरत नहीं है वो 15 वाला एसआर पास करने की। फिर वुमन डायरेक्टर, फॉलोइंग कंपनी शैल हैव एटलीस्ट वन वुमन डायरेक्टर ऑन देयर बीओडी। कौन कौन सी कंपनी है, एवरी लिस्टेड कंपनी, एवरी अदर पब्लिक कंपनी हैविंग ऑन लास्ट डेट ऑफ लेटेस्ट ऑडिटेड एफएस पेड अप कैपिटल ऑफ रुपीज 100 करोड़ and turnover of rupees 300 crore or more. Note, a newly incorporated company shall comply with above requirements within 6 months period। तो 6 months period में ये कर लो। फिर any intermittent vacancy shall be filled at not later than immediate next board meeting or 3 months। जो ऊपर वाला पॉइंट है, from the date of such vacancy whichever is the independent director, minimum number of independent directors, every listed public company, one third of the total directors, any fraction rounded off as one, following public company shall have at least two independent directors। तो दो independent directors if having paid up share capital 10 crores, turnover 100 crores or more, or outstanding loan, debenture or deposit exceeding 50 crore in aggregate। Note, any intermittent vacancy shall be filled at not later than the immediate next board meeting or at immediate next board meeting or 3 months from the date of such vacancy, whichever is later। The company shall not be required to appoint independent directors if it ceases to fulfill above criteria for three consecutive years: joint venture, wholly owned subsidiary, and dormant company unlisted not covered under the above। Now, qualification for being independent director। तो कौन कौन बन सकता है इंडिपेंडेंट डायरेक्टर? हु इज नॉट अ मैनेजिंग डायरेक्टर, होल टाइम डायरेक्टर और नॉमिनी डायरेक्टर जो नहीं है, हु इज नॉट अ प्रमोटर और नॉट रिलेटेड टू द प्रमोटर or director in the company's holding subsidiary or associate company, who had no pecuniary relationship other than the remuneration or having transactions not exceeding 10% of his total income with the company, its holding subsidiary or associate company, or the promoters or directors during last two financial years or during current financial year, whose no relative is holding any security or interest in the company's holding subsidiary or associate during last two financial years or during current financial year। However, relative may hold up to face value of not exceeding rupees 50 lakhs। तो relative hold कर सकता है कितना, रुपीज 50 lakhs और 2% of paid up capital indebted to the company's holding subsidiary or associate company or the promoters directors in excess of rupees 50 lakhs during the last two financial year or during the current financial year, given a guarantee or provided any security for loan by third person to the company is holding associate। तो यहाँ पे ना सब क्वालिफिकेशन दी गई है वो, ठीक है, अगर आए तो देख लेना। फिर एसोसिएट कंपनी मींस कंपनी इन विच अदर कंपनी हैज सिग्निफिकेंट इन्फ्लुएंस मोर देन 20% ऑफ कैश फॉर वोटिंग पावर, बट इट्स नॉट अ सब्सिडियरी बट इंक्लूड्स जॉइंट वेंचर कंपनी। नाउ, रेम्यूनरेशन ऑफ इंडिपेंडेंट डायरेक्टर। Remuneration of independent directors. Independent directors is eligible for remuneration by way of sitting fees, reimbursement, or for attending board meetings, profit-related commission approved by member. However, not entitled to any stock options। तो stock options के लिए वो लोग entitled नहीं है। फिर sitting fees payable to the independent director should not be less than the fees paid to the another director। फिर tenure of independent director. Independent director should hold office for up to five consecutive years, may be reappointed for second term after passing special resolution। Terms of less than 5 years shall also be counted as one term। फिर a reappointed independent director may be removed only by passing a special resolution। Independent director shall not hold office for more than two consecutive terms, again eligible for reappointment after 3 years of holding period। फिर है अपॉइंटमेंट। तो टेन्योर ऑफ इंडिपेंडेंट डायरेक्टर ये सब है ना, इंडिपेंडेंट डायरेक्टर का पॉइंट है। तो इंडिपेंडेंट डायरेक्टर का पॉइंट यहाँ पे आके लेना अगर कुछ आया तो। फिर अपॉइंटमेंट ऑफ डायरेक्टर सेक्शन 152। तो फर्स्ट डायरेक्टर है, आर्टिकल ऑफ कंपनी कंसिस्ट ऑफ नेम्स ऑफ फर्स्ट डायरेक्टर्स if not subscribers to the memorandum shall be considered as first director। In OPC, the only individual, not any body corporate, shall be deemed its first director। This first director shall hold office till the holding of first AGM। फिर subsequent directors क्या है, every director shall be appointed in AGM except companies that provide separate procedure। फिर retirement of directors by rotation। This provision is applicable only to the public company and any private company which is subsidiary of public company, unless the articles provide for retirement of all directors at every AGM not less than two-thirds of the total number of directors shall be person whose office is liable to be determined after for the rotation। Total number of directors shall not include independent and nominee directors। Independent or nominee directors नहीं आते as they can't be retired by rotation। In every AGM except first AGM, one third of the directors liable to be determined for rotation as per above limit shall be liable to retire by rotation if one third is coming in decimal number the nearest shall retire। Decimal number nearest shall retire। Director who served longest shall retire first if same to be decided mutually or by lot। फिर vacancy created by retirement may be filled by the company at the AGM by retiring directors or others, but the requirement of minimum directors must be fulfilled. In case AGM is not held on due date, directors shall be liable to retire or shall vacate their office on the due date of AGM. Deemed reappointment of retiring director. If vacancy of retiring director not filled and not resolved expressly not to fill, meeting shall be adjourned to the same day in next week at the same time and place. If national holidays on next day, if vacancy of retiring director not filled up in adjourned meeting, also then the retiring director shall be deemed to be reappointed except in the below mentioned cases. If in the meeting or previous meeting resolution for reappointment of such director has been put and lost, if he has expressed unwillingness to be reappointed in writing, if he is disqualified for such appointment, if an ordinary or special resolution is required for reappointment, and if section 162 is applicable, that is where single resolution passed to appoint two or more persons as director without first moving proposal against which no vote has been cast. No, if following companies are exempted from provisions of rotation and reappointment as above, if it has not committed any default in filing financial statement under section 137 and annual return under section 92, government company not listed in which CG or SG hold at least 51% of the paid up capital subsidiary of above mentioned government company. With appointment of directors elected by small shareholders section 151 आ जाता है. Listed company may optional have one directors elected by small shareholders holding shares of nominal value not more than 20,000. Listed company may appoint directors elected by small shareholders on notice of at least 14 days, but by not less than 1,000 shareholders or one-tenth of the total number of shareholders, whichever is lower. फिर आ जाता है such director shall be considered as independent director and should meet the eligibility criteria prescribed for the independent director. फिर such director not liable to retire by rotation and maximum tenure shall not exceed 3 consecutive years or also on expiry of tenure such director shall not be liable to be eligible for the reappointment. फिर appointment of additional director, alternate director, a director to fill casual vacancy and the nominate director. So additional director क्या है? Considering urgent requirements, board of directors may appoint any person as the additional director only if empowered by articles or of association. Following person cannot be reappointed as additional director. Person who fails to get appointed in general meeting, persons should not be a retiring director. Such additional director tenure should be limited to coming AGM. In case such AGM is not held on due date, tenure ends on the due date of the AGM. With alternate director, the board of directors The board of directors, if authorized by its article or by a resolution passed by the company in general meeting, appoint a person to act as an alternate director for a director during his absence for a period of not less than 3 months from India. Some condition to meet for being alternate director. Person not being director or alternate director for some other director in कोई दूसरे company में नहीं है and person for being appointed as alternate director to be independent must fulfill criteria for independent director. Note: such alternate director shall not hold office longer than permissible to the original director. Such person shall vacate office as soon as the original director return to India or even on death of the original director. Provision for automatic reappointment to original director shall not be applied to the alternate director. Such person shall accept appointment only if his existing directorship doesn't exceed the maximum limit. Directors to fill the casual vacancy. If director appointed in general meeting vacate the office before the expiry of its term, that is death, resignation, or removal, such situation is called as casual vacancy. In such case, board may fill such vacancy which must be approved in the immediate next meeting. Note: filling casual vacancy is not mandatory. If casual vacancy get vacated again due to some casual occurrence, same can't be said as casual vacancy. In such case, casual vacancy can't be filled. However, additional director can be appointed. Even after approval in general meeting, such person shall continue his term only for the unexpired term of the original director. Maximum number of directorships. Section 165. A person cannot hold office as director, including alternate directorship in more than 20 companies at a time. Out of 20 companies, public companies should not exceed 10. Public com- 10 public companies include private companies holding or subsidiary company of public company. However, dormant and Section 8 companies shall not be counted in the limit. A company may specify lower limit for its directors through the special resolution. That was chapter 1, appointment and qualifications of directors.